In the Karen Read case, wait, what? Michael Proctor, the disgraced Massachusetts State Police trooper, lost his phone? What? And what was in a mystery email reply sent by Karen Read, special co-host with me on this edition of About the Law, Alexis Room. How are you, Alexis?
I'm doing well. How are you doing, Andrew?
I'm good. Let's launch into it.
You lost. And you know what you did.
The Karen Read cases, plural, have had a lot of ups and downs. And today, and I know you know this, Alexis, I know you know this, but sometimes it can get confusing for people that only hear us once a week. And that is that we're talking today about the lawsuit that was brought by the O'Keefes against Karen Read and the two bars for the wrongful death of John O'Keefe. And it's getting kind of deep in the case, isn't it?
It definitely is, but as deep as it is, it seems like we are a far cry out from seeing actual trial. I think you might agree.
Oh, absolutely. I think I checked a couple of episodes ago, and if you go into the docket, it's not even scheduled until sometime in 2027. So, and who knows if that will hold, but there was a hearing a couple of days before we're recording this episode, and the judge, Mark Gilday, a good Massachusetts Superior Court judge, is expressing, I think it's fair to say, some frustration that even at this early point, it's going as slowly as it is. Did I read that right?
Oh, absolutely. And there's so many different hands in the pot right now as well, too, because you don't just have the O'Keefes, but you also have the Waterfall Bar and Grill and those attorneys. So there's a lot of moving parts for sure.
I counted 24 attorneys have signed into the case. I can show you the list in a few minutes when we get going, but I went into the court docket and I took a look at the notices in the most recently filed documents. 24 attorneys have actively signed in, and we're about to see about half of them, 11 of them, participating in one of these Zoom hearings. But before I do, wait a minute. A friend of mine who's a journalist said, Andy, don't bury the lead. I'm burying the lead. Michael Proctor says he lost his phone. First of all, do you believe that?
Absolutely not. I mean, it's as ridiculous as Brian Higgins saying, oh, it's normal to dispose of your SIM card in two different garbage bags along with your cell phone after, people are looking for you to hand in your phone into Discovery, and then Brian Albert having to upgrade his phone as well too after he had to turn that over. So it's just a series of coincidences, and when do coincidences just become absolutely ridiculous excuses?
And Mr. Proctor had his issues. He's been dishonorably discharged. He's been decertified. People have said all kinds of things about him. I don't know. So this latest, what does he have to lose other than to say he lost his phone? Although, you know what, Alexis? I mean, didn't he learn his lesson from the hearings in Judge Krupp's courtroom, where Judge Krupp was looking at first, I think, 3 or 4 cases, and then later on 19 cases, in which Proctor's attorney had said, oh, well, he got a new phone and it deletes every 30 days, I think is what he said. And then it turned out that everything going back 13 years was up in the cloud. So you'd think he'd learned his lesson. I don't know.
Yeah, well, and the interesting thing, too, as we're going to go over in just a minute, I'm sure, is the fact that the district attorney's office has a copy of these records, but it's a lot of, well, we can't hand these records over to you. You have to get them directly from Mr. Proctor, because now he's Mr. Proctor. He's not even called Trooper Proctor anymore. But you have to get all of this stuff from Proctor, and thus came the conversation of, well, I don't have my phone anymore, but it's just interesting to me because from my understanding, he has an iPhone, I'm assuming. Can't you still find a way to access that data from the cloud in some way? So I'm curious to see how this continues to unfold.
Well, you're absolutely right. I mean, sometimes people come after us for telling stories, but I lost my iPhone one time. And I knew I had it when I woke up in the morning, but about 10 o'clock in the morning, I realized, wait a minute, where is it? So I retraced my steps. I rewalked the dog. I went back over the morning walk. I even went down into little gullies where the dog likes to, go down and be a dog. And I had only done one errand, and I went over there, looked and looked and looked, and asked the people there, did anybody? So my phone was lost. My iPhone was lost, and this has only happened once. So I went to the Apple store, and I told them, and of course they wanted to sell me a new phone, and of course I bought a new phone, but they're really nice. They're all techies. They're all kids, and they were only too happy to help me, laughing at me. Alexis, when they were all done, it took a while to download all the stuff, but when they were done, everything was there. Everything.
Yeah. Isn't it amazing how that works? I have conversations from, years and years and years ago from people I don't even remember. Like, I have 50 different mics in my phone. I don't even know who half of them are, but I have these long threads of conversations dating back to like 2017, because it is really easy to get everything transferred over. But I guess whether or not Karen Read's team is able to get that information or not and have access to that, because at the end of the day, the phone is just the hardware. It's what's stored on there that matters. And I just think it's so funny because we're in a day and age where everything seems to get bigger. iPhones went through a phase where they were practically invisible. They were the size of my AirPods case. Exactly. But now they're the size of mini computers practically. So I find it absolutely ridiculous for people in this day and age to actually lose their phone. I know it happens, but especially as conveniently in the time frame that he's claiming he lost it.
Well, the Norfolk County District Attorney would have it, and I don't see any reason why the court would not allow a subpoena to get it all from whoever the provider is. Right. I mean, I had the same experience as you. We had taken the grandkids on a vacation, beautiful vacation down to the Dominican Republic. And of course, the kids are kind of growing up now. And so those were irreplaceable photographs. There they were. Like you said, my texts, my emails. As an attorney, whenever I get a new client, I put their information in my iPhone, so I have it all. It's all right there. It's all, and it all came. Thank God, it all came. Now, of course, I keep it, backed up elsewhere, but it all came back, and so it's there. The Norfolk County District Attorney would have it. But let's get into this hearing that was held, and it was held on Zoom, and the judge was not happy with the way the thing has been taking so long. So the first person we're going to see is the attorney for C.F. McCarthy's, Tamara Smith is her name, and she was explaining that she's having major technical issues when she gets discovery. Some of it won't open, and so she's having a hard time with all of this.
Now we're put in the position of trying to take what has been produced and get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved, just as Mr. Diller is, to try to better access these documents. And then I would just say to, from what I have been able to see with the 518 videos, they're not, as far as I can tell.
Wow, 518 videos. Is that a lot or not a lot? Seems to me like a lot.
It feels pretty hefty to me, considering the lack of video footage from at least the Commonwealth's end in the criminal case. And I'm assuming she's talking about Karen Read's team and what they're providing to the O'Keefe's, correct? Yeah.
Yeah, so that's what she's talking about.
I'm curious what her private investigator and what her team has been able to pull and from where.
Interesting point. Well, let's keep going with her talking about what's in some of those.
Categorized in any way. My operations manager has told me that we can see that there's driveways, there's Ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date and time stamped. We're having a difficulty sort of trying to weed through it and discern what is relevant and what is not relevant from those videos. And then with respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me.
So that raises a couple of issues with me. The first one is they have videos of cars backing. I assume that is Karen Read's car backing into John O'Keefe's car in the driveway that morning. You don't think they have the mysterious, non-existent video of her backing into John O'Keefe?
I would guess probably not, because if they did, I mean, we wouldn't be here talking about this case now in 2026. This would have been open and shut. The Commonwealth would have had all of the evidence that they needed to prove that John O'Keefe was struck by a car, but we know that, I feel confident in saying we know that that just isn't true. So I am curious what kind of Ring doorbell footage they're referring to, if it's stuff that, because I think they did pull in the criminal case from Karen Read's parents' house in Dighton, correct?
Yes.
If I'm
Yeah, they
remembering
did.
that
Yeah.
correctly.
Yeah.
So I don't know if it's just more of that or if there's other, and then body cam footage as well too. I'm probably her arrest video footage that we've seen circulating around the internet over the last few months. But is there more? Is there more that we just haven't seen?
Well, yeah, I was just talking about that. I think you remember this. One of the Boston TV stations, and I actually remember this going back to 2022. One of the Boston TV stations said, "Oh, yeah, there's actual video of Karen Read backing your Lexus into John O'Keefe." And they never retracted that, even though there's no such video. There's no such video. But
yeah, I remember that clear as day too, and everybody just kind of wrote off this story as well. It seems pretty open and shut. There's video footage, you can't dispute that, of her hitting John O'Keefe with her car, open and done. And then we started to hear about all of this other stuff about the House Long to Die in Cold Google search, and obviously we're not going to talk about this in this video, but it just kind of spiraled from there. So I am really curious to know what is allowed into discovery, what exactly, 518 video files, she said, or files in general?
she said 518 videos. 518. There are, like you said, there was Karen Read's arrest and then in jail. And then, when she was in the holding cell. And then recently, just before the holidays, when the Proctor and the others, Buchanan, I believe it was a Buchanan or Proctor, went over to her parents' house. No, went to her house. And they were going around, walking around in the snow. So, yeah, there's a lot of videos out there. I don't know if there'll be anything new because in a civil case, there's a lot more discovery. In a criminal case, it's all controlled. And although the district attorney and all law enforcement have their Brady obligations, as we've seen, they didn't necessarily adhere to those. And as we've seen, they weren't necessarily forthcoming with discovery. So in my view, I might be wrong, in my opinion, there will be a lot more discovery in the civil cases, plural.
Totally, and I think, and I'll make this last point before we continue on. I
Okay.
think on bringing this case, even though it wasn't Karen Read's idea, the O'Keefes brought this particular case. I think it's the best thing for her, and just telling the truth and giving everybody a full perspective of what actually happened or could have happened, as close as we can get to the truth.
So one of the problems is just the sheer volume of discovery, and that files aren't opening, and they need, these discovery experts to help them. I've had these third-party discovery people contact me, and we'll help you with that. And it's unfortunate because we're talking about discovery. In the old days, and I'm old enough to remember, unfortunately, in the old days it was all paper. And if there was film, they'd actually send you a duplicate of the film, or they'd actually send you photographs. Now it's all electronic. And one of the problems is you might have different types of files. You're going to have PDFs. You're going to have MP4s. You're going to have, MP3s. You're going to have GIFs. You're going to have, and the problem with those is that they frequently update themselves. My PDF recently updated itself, and I had problems with the PDFs we're going to show in a few minutes. So they might put it all together on day one, but by the time they send it over there, the receiving attorney is unable to open it all. I think that's what they're talking about. So
yeah, I agree.
And I have that problem. That stuff upgrades all the time, and when it upgrades, it doesn't necessarily mean that it's getting any better. So one of the attorneys we saw the attorney for C.F. McCarthy's, but one of the attorneys for the Waterfall, the other bar, David Hassett, also describes some electronic failures he's had with the discovery materials that he has received.
They will open up and they'll be blank, there'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr. Rosenberg's office about some access to files in our own IT support.
That's Hassett all the way down on the bottom right-hand screen. I tried to blow these up, but the resolution is such that by the time I blow up the individual squares, it's horrible. You can't see it. So
No,
that's
perfect. Yeah.
That's why we have Mr. Hassett all the way down in the bottom right-hand Hollywood square, sitting next to one of his partners, I guess.
Internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata. It appears that will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
Did you hear that? Metadata in the Karen Read case.
What a concept, right? I can't help but think, and maybe this is just my millennial brain thinking, but I feel like they would save a lot of money, all of these attorneys, just hiring or employing a very smart, savvy team of interns, college students who are very tech savvy and could probably easily organize and put together a lot of these things. I don't know how much these third-party vendors do. I'm sure you have a better idea of that, but it just seems like this seems to be an ongoing thing. We've seen this happen as well in the Turtle Boy case too, if you've been following that. And, where attorneys aren't able to access certain things, there's pages upon pages of just blank documents, right? Or overly redacted without rhyme or reason why. So I am curious if this is, partially just because of the fact that they just simply don't know how to work the technology, or if this is also being done maybe as a tactic to continue the delay game on all parties' ends too, to buy them some more time.
No, I agree with you 100%. It's always good to have a 20-something around, whether it is a paralegal, whether it is an intern, whether it's an office assistant. I've been lucky enough to have people that just know this stuff inside out, which I don't, and I'm willing to admit that. I'm an attorney. I'd like to say that I understand the law. I know how to do research and argue things in court and write memoranda, but I'm no tech expert. I think you met my first co-host, Lainey Law, who I'm still in touch with. She was real bright. She was very bright with tech stuff, and not only with my YouTube channel, but also often with troubles I've had in my office. She was a troubleshooter. So yeah, I think a lot of these attorneys, if they're spending their clients' money, they don't care, and so they hire these third-party providers that come in and help them. But if you have a bright person who understands this stuff, like you said, an intern or whatever, you're not going to spend all the money. But the thing that really stood out to me in Attorney David Hassett's statement was he was talking about metadata. And remember the good old, and I shouldn't call it that, the inverted video, which the judge refused to allow an order to provide the original with the metadata. That would have squared the whole thing away with respect to whether the thing or how the thing or when that video was inverted and who did it and why. And, the judge seemed to either not understand what metadata was or overlooked the fact that the metadata would have, shown the corruption behind that inverted video.
Right. Well, it just becomes a game of, is it a coincidence, or is it, again, a lack of just not knowing what these terms mean? And I hate to be that millennial, but it's the 21st century. We gotta get with the times here. Things are evolving. The way that these new systems are being placed now, you just gotta kind of adapt to it. And I feel like sometimes, and it's not just at the fault of attorneys, or I know that there's a lot more that goes into it than my layperson brain can possibly comprehend. But even the court system's as simple as figuring out how Zoom works, right? All of these things can delay the process. And it's just, it feels a little unnecessary at times. But yeah, I mean, it's just interesting where we see where they choose to rely on metadata, where it's an important piece of conversation and where it's not. When it's a matter of turning over screenshots, well, that doesn't matter. It doesn't matter where the screenshot of this text message thread came from, because who cares? We trust the word of Jen McCabe. We trust the word of so-and-so. Who needs metadata? Who needs the proof? Yeah.
Well, two things come to mind. And one is, there's no excuse for anyone since the pandemic to not know what Zoom is. I'll admit, I had used it once or twice, but I was very unfamiliar with Zoom. But I mean, if you don't know what Zoom's all about since the pandemic, you're a lost cause. B, there is no excuse for anyone in the legal system in Massachusetts to not understand what metadata is. And I say that because many years ago, I don't even remember how many years ago, the Massachusetts Lawyers Weekly, which is a publication that all attorneys in Massachusetts who care about their jobs read, and people on the bench and people elsewhere read it. I remember a front page article many years ago, watch out for metadata. And I'm like, what the hell is metadata? Because I didn't know then, but it was an in-depth article and then some follow-ups after that about, watch the documents you send out, watch the photographs you send out, because the metadata is going to tell opposing counsel where it came from, when it was generated, who edited it, et cetera, et cetera, et cetera. I learned that from Lawyers Weekly many years ago. So there's no excuse for anyone in the legal system in Massachusetts to not understand what it is. And I guess that's all I'll say about that, because it's just, we should all know about that. And it's very crucial and it's vital, especially when there is a question about the authenticity of a video. So
100%.
One of Karen Read's attorneys, Aaron Rosenberg, then said that this was the first time he's heard about those electronic failures we just heard about, but he's willing to work with the others under questioning by the judge. Rosenberg explained difficulties he's having getting responses to subpoenas for both documents and depositions. And one name, familiar to you, kept coming up.
Which is the only deposition that's scheduled thus far in this case, is our deposition of Michael Proctor, which we've finally locked in with everyone's availability, all parties, counsel, and Mr. Proctor and his counsel's availability. And that'll be going forward in April. We have not yet scheduled other depositions, but we from the Read side plan to do so very shortly. And as you can tell, obviously the discovery from our end is going to be primarily third-party discovery. So there will be additional depositions put on the calendar soon as we're able to coordinate schedules, which has obviously been daunting.
So third parties, what he means by that, specifically, he mentioned Massachusetts State Police, Sergeant Good, Mr. Proctor, as you point out, we really shouldn't call him Trooper anymore, the town of Canton, and he mentioned some others. So those are third parties because they're not necessarily direct parties. We already have enough parties in this lawsuit. So the third parties are the people outside of that. And then Rosenberg explained reasons why this discovery is taking so long in the case, one of them being the Norfolk County District Attorney resisting requests over Mr. Proctor's phone, which Proctor now claims, and here's the context, that he lost.
In some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for two and a half months negotiating an agreement with the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents.
So I'm listening to this. It's 12 to 15 minutes in, and even for me, a civil attorney who spends a lot of time in discovery, I'm going, gee, what am I going to have for dinner tonight? And then I hear this, and I'm like, wait, what? What did he say? He buried the lead. So let's hear that over again.
As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone.
Wait a minute. So what are your initial thoughts now that you've heard that a couple of times?
I mean, there are so many thoughts. I do want to quickly backtrack to him dodging the subpoena. This isn't unfamiliar territory for Mr. Proctor. Again, referring back to the Miles King case, which is relevant to where these records that they're referring to in the DA's office that are just magically hanging out there. What else are you going to do with those records if not destroy them? He was subpoenaed, to my recollection, he was subpoenaed to show up in court the first time where they were going to. It wasn't just related to the Miles King case, but I think Rosemary Scapicchio, if I'm recalling correctly, made sure he was hand-delivered a subpoena for him to appear in court. And he was like, I was on vacation this whole time.
I remember that. You're absolutely right. Yeah.
I was on vacation. It's been planned for months. How dare you hand deliver this thing to me? And I'm above the law. It's very much, even though he's been erased completely from the MSP at this point, he's lost all his privileges. He's just Mr. Proctor. He still believes that it's the way it comes off to me. The law does not apply to him. He doesn't need to do anything because he's smarter than everybody, even though clearly he's not. And he doesn't need to obey by the law and comply. And so I wanted to backtrack to that. So first, he did.
No, thank you. No, that's good perspective. That's really good perspective. And actually, he, like you said, he had been subpoenaed to appear in that case. And Rosemary Scapicchio cross-examined Adam Lally, which I shouldn't laugh, but it was entertaining, as sad as it was. Now, we have no procedure really to, keep up with Proctor or anyone else who's out there, subpoenaing documents in the King or any other case. Right. So then Proctor that was the day I think that Proctor was supposed to show up. He didn't even show up. And then he did show up at a subsequent hearing, but he was, they never even put him on the stand. So keep going. No. I'm sorry.
Yeah. No, you're absolutely correct in all of that. Yeah, that was when he was still being represented by Daniel Moynihan,
right? Who
is no longer representing him. No. That was around the time where the council had said, "Hey, we're going to drop this hearing. You can't get your job back, essentially." And then fast forward today, but I don't. Do you know exactly what the time frame was between him getting his phone back and him getting his new attorney for this particular case?
Well, when he got the phone back, what happened was that his attorney, Moynihan, withdrew immediately. Right. And I don't think it was Moynihan's necessarily decision. I think the board of the union, which is obligated to defend troopers and law enforcement, the board voted that we could no longer, support this. Some things are just indefensible. Right. I mean, everybody has a right to a defense under the Sixth Amendment of the United States Constitution. But this was an administrative hearing. I'm pretty sure this was an administrative hearing, and it was reported. We still don't have all the contents of those phone records. I'd love to have them, but it was reported that they were misogynistic and homophobic and God knows what else. And so that's when the union said, no, you can't.
Well,
so
the thing that was...
Go ahead.
Oh, go ahead. I was going to say, and the thing that was most shocking to me was that he had photos of children. I don't know to the extent of whose children they were, who he was sending them to, who these text exchanges were going to, but that was the most shocking revelation from that for me, was that there are images of children. And again, I don't know in what context. I'm not going to over speculate on that, but I mean, it just goes to show it's like what what exactly, as you said, what exactly are the contents of these phone records? And
Yeah,
dating
what are
back
we
to
dealing with?
2013.
It
Yeah.
sounds pretty bad. It sounds even worse than the things we heard him read on the stand in trial one. I mean, we heard him read all that stuff. And
Oh yeah. Yeah, that was nothing compared to the latest revelation. So I can understand why this would take a lot of time and trying to even get him to comply
Yeah.
and to do the thing he's supposed to do. But the reason why I asked if you knew what the time frame was between him getting his cell phone back and I probably worded this incorrectly, and getting his new representation. It felt like, because it sounds like they're making it out to seem like it was a short period of time, but I do think it was a lot longer before he secured his next legal
it was a
counsel.
period of time. I thought. I don't know exactly, to be honest with you. I don't know.
Yeah.
We'll have to check that out if my viewers, who always love to correct me, by the way.
Oh, mine too.
Oh.
So please feel free.
Sometimes the corrections are not correct, but in this case, if anybody knows that exact date, I think it was right before the holidays, wasn't it? I mean, I don't know.
Yeah.
I really don't.
Yeah.
In this case, let's wrap this up with this hearing. Rosenberg had explained that the Massachusetts police have produced no documents in response to the subpoenas. And Judge Mark Gilday is obviously not happy. He has expressed displeasure with the slow pace of this case.
February, when we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but why don't you utilize the court to maybe relieve that frustration? If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This case...
Can I just be clear?
It needs to start moving along.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations. The rules, I believe, would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way when we get non-compliance from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
I'm not suggesting you ignore any of the rules. I'm suggesting you avail yourself of the opportunity to use them.
Okay, so Massachusetts has this convoluted, and I actually wrote an article about it many years ago. We have a convoluted motion practice that says if I want to file a motion, I can't in Superior Court. I can't just file the motion. I have to send it over to opposing counsel, give them 10 days. Often they ask for more time. Then when the time goes by, I put it all together in a package, and we're going to see a motion that followed this in a minute, and then submit that to the court. That's Rule 9A. 9C says you've got to confer with the other party. In other words, if you and I are in litigation, before I file my motion, I've got to contact you somehow, effectively, email, telephone, letter, somehow, and engage you in a discussion to see if somehow we can narrow these issues. And the courts imposed that. And again, I wrote an article on this years ago because the courts really do not like this discovery morass, I'll call it, because they don't like getting their hands dirty in it. They like to have trials. They like to have the evidentiary arguments. They like to, make sure that a fair jury is picked. So this discovery nitty gritty, they just don't like it to begin with. But that's what the 9A and the 9C that he was talking about were all about. I can kind of understand. I know a lot of people will question this, but I can kind of see Attorney Rosenberg's point. I don't know him. I've never dealt with him. I have nothing to do with him. But from July to February, it goes by awful fast. You've got the holidays in there. He's dealing with multiple parties, which we just mentioned, the Norfolk District Attorney's Office, which, is doing everything they can to stonewall, the Massachusetts State Police, which isn't much better, and all of these other individuals. So I can see how it can go from July to February, and I wouldn't want to be sitting in Attorney Rosenberg's chair with the judge kind of needling him. Let's get moving, dude. Let's move it along. So as a layperson, but a smart layperson, I love your insights. What are your thoughts about the judge really getting down on the attorneys for making it take so long?
I mean, I think the judge shares a lot of the same frustrations that the public does as well, too. We're all eager to just see this thing go to trial, and see if there's more information that, again, we haven't been privy to seeing beforehand in the criminal trials. I also don't blame him as a judge. I mean, I'm assuming he's been there, done that, got the T-shirt. You know, he's been on the attorney end, I'm sure, having to go through all of the same things that the attorneys right now are going through. And he does just want to probably show up, do his thing, sit on the bench, make a ruling, end the day, clock out, you know, make it in time for happy hour, and just get on to the next thing. And I understand that. And I actually like how down the middle he seems. At least that was the impression that I got from this hearing. It doesn't seem like he feels particularly leaning towards one side or the other. And it seems like everybody on the panel is kind of at fault at this point for this delay game, and not necessarily because it's all of their fault, but because of, you know, again, trying to get in contact with Proctor and trying to get these records from the DA's office. And there are just so many other hoops that they have to jump through. So I think it is just going to be one of those cases where it's going to be extremely long and drawn out, and there's just not a whole lot that anybody can really do about it. But regarding your explanation, which I appreciate, not being an attorney and not being an attorney from Massachusetts, about those different rules, I kind of got the impression the judge was like, hey, use me. You know, I can expedite this process a little bit more if you need me to step in. I can do that for you.
Yeah, that's a good perception, actually, because, you know, we have that rule, but there are deadlines. You only have to give the other side 10 days. And like I said before, often attorneys like me, I'm the dog ate my homework guy. I'll often, when I get emotional, I'll call the other side and say, can I have another 10 days? And 9 times out of 10, a good attorney, even though we're at our clients are each other's throats, 9 attorneys out of 10 will say, sure. But that's only 20 days. And to do the conference, again, 10 days. If I notify you, I want to file a motion, I want to conference this. If 10 days go by, I can say, you know, look, I gave you the opportunity. Now you bend over backwards, but yeah, to let it go 7-8 months, I don't know, but I agree with you. This is a very fair judge. When Judge Gilday was brought on to this case, and I'm not saying it, I do have cases pending in the superior courts. As far as I know, he is not on any of my cases, and I don't have anything before him, so I'm not saying it for that reason. But he has a very good reputation. Things are going to be very different in this case. As you pointed out, he appeared to be extremely fair. He was giving, you know, all the attorneys, and we didn't get into the whole thing. I know other attorneys have, but to sit there for 20 minutes and watch the entire thing, I think would probably lose any viewers we have left at this point. Now, what do you think about this other issue that we're going to take a look at now? Apparently, KarenRead pressed reply on an email that had come in, and then her attorneys had some thoughts, and the attorneys sent KarenRead a email that came in from opposing counsel, and Karen did not realize it, is what we're being told, and she hit the reply button, and the attorneys for the O'Keefes got her reply. We don't know exactly what it says, but they're fighting over that. The attorneys for KarenRead immediately said, hey, this was inadvertent. It can happen to anyone. We want you to not keep that and to get rid of it. And they're fighting back. They're saying, no, we don't have to. Huh.
Yeah, I mean, it seems quite obvious. The strategic move from, you know, the O'Keefe side is we want to use as much information as we can to, you know, prove our case as best we can. And if we can use this thing that seems like it, I don't know, it might make her look bad in a light. Again, like you said, we have no idea what the context or the email said. If it was anything of substance, if it could make her look bad, they want to use it potentially to, and it seems like they were inferring this, to potentially impeach her later down the line, pull it out of their back pocket. There's a lot of argument about, did she waive attorney-client privilege? So I'm very curious to hear your perspective on this.
Okay, let's take a look. Let's take a look at the pleadings. So I just want to make sure you can see that okay over there. Okay, this is the memorandum of law in support of defendant Karen Read's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication. And it's not that long of a motion, so I'll go over as much of it as I think I can. I had a cold about a month ago, and I'm still having some problems with my throat. So if I'm popping, cough drops, that's why. Defendant Karen
as long
Read.
as it's cough drops and
What's that?
not anything. As long as it's cough drops and nothing else.
Okay. We're not going to go there. Defendant Karen Read respectfully requests that the court order plaintiffs to destroy all copies of an email that Read inadvertently sent to plaintiff's counsel on December 16th, a week and 2 days before Christmas. Read accidentally replied all to an email on which she was blind copied, which unintentionally included plaintiff's counsel on her otherwise privileged message. The reply all email directly related to Read's legal representation in this case. Despite numerous requests that began 39 minutes after the reply all email was accidentally sent, plaintiff's counsel refuses to delete the email, temporarily sequester the message, or even seek the court's instructions. So that's pretty fast, actually. I think that's a key fact here, that only 39 minutes after Karen made that inadvertent mistake hitting the reply all, only 39 minutes later, her attorney contacts the plaintiff's attorney and said, hey, we made a mistake. Anybody can make a mistake. That is a communication that is protected by attorney-client privilege. Let's get rid of it. They said, delete it, sequester it, whatever. They didn't do so. So therefore, Karen Read seeks an order requiring plaintiff's counsel to delete the message and any copies and recover and ensure deletion of any copies sent to his clients or anyone else. Analysis. On December 16th, Read's underside counsel sent an email to plaintiff's counsel and blind copied Read so that she would be aware of this email. Read mistakenly replied all to the email to share her thoughts on the legal issue. Now, exactly what those thoughts are, we don't know. We have a hint, but we really don't know. We don't have that legal issue that was the subject of the message, which meant that plaintiff's counsel, the attorney for the O'Keeffes, was inadvertently included on her response. 39 minutes later, another of Read's attorneys replied all to Read's email, informed all recipients and particularly plaintiff's counsel that the email had been inadvertently sent, and instructed plaintiff's counsel to delete it without reviewing the message. Read's counsel then followed up shortly thereafter, reiterating these instructions and requesting confirmation that plaintiffs had complied. Instead, plaintiff's counsel suggested he would not. They're digging in their heels here. Despite the obvious context clues, he claimed that the email from Read had appeared to be directed to him. I don't see how that can be true. You would know whether somebody's hitting reply or directly contacting you, I would think.
Yeah, that's what I would think. And, I can understand everybody makes mistakes. And as we just saw from the hearing a few minutes ago, half these attorneys don't even know how to access certain files. So it just goes to show mistakes can happen. Things can go wrong. And I'm sure it's easy to understand that when you're, somebody in Karen Read's position who we know is usually pretty involved in all of her cases. She's talked about that a lot. Her attorneys have talked about how involved she is in her case. That she's probably got billions upon millions of different email threads going on, and it's just easier sometimes to hit reply all. You're not always looking, especially if she was looking at her email on her phone. You're not checking who's on the thread because you just trust that, hey, I'm just sending this to the respective parties, my attorneys, and none the wiser. And yeah, I agree. I don't think she purposely would direct communications like that to the opposing counsel. But my question is, did the O'Keeffes get to see this email communication? Was that shared with?
That's a good question for our viewers. I would bet the coffee money, not the mortgage money, but I would bet the coffee money that those attorneys immediately called the O'Keefes and said, "Hey, look at this, haha." So let's continue with what the plaintiff's counsel, the O'Keefe's attorneys, are saying. They're saying that somehow Reed's mistake, corrected minutes later, resulted in some undefined waiver of the attorney-client privilege. Those are heavy words, because what they're saying is that, hey, we got this email, and so that waives the attorney-client privilege. And Karen and her attorneys are saying it was a mistake. It's easy to make a mistake. As you just said, Alexis, it's, we all make mistakes. We're not perfect, and later down in these documents, we're going to see people are saying that. But in any event, they are saying that this resulted in some undefined waiver of the attorney-client privilege. Reed's counsel followed up with plaintiff's counsel multiple times, explaining counsel's obligations under the applicable rules of professional conduct and case law, but to no avail. Plaintiff's counsel refused to delete the message, even sequester it or seek the court's instructions. I think our rules would require them to do one of those three things. That's my opinion. Mm-hmm. Although most cases regarding the inadvertent disclosure involved an attorney accidentally producing in discovery a document that should have been withheld, Massachusetts courts have faced this issue before. So what Karen's attorneys are saying, hey, guys, there's already applicable case law on this subject, and you guys are in the wrong. Specifically in 2010, and in the law, which changes slowly, that's like yesterday. That's a new case.
I know.
It's true. Judge Fabricant, good judge, I've been before her, Superior Court judge, decided that a client who replied all to an email to opposing counsel after being blind copy had not waived the attorney-client privilege. Okay. So it sounds good, but we have to dig into the facts a little more. This is the case of Charm versus Cone, Superior Court case. In that case, Judge Fabricant applied the standard that would apply in the more common scenario. Quote, a client does not lose the benefit of the attorney-client privilege for an otherwise privileged communication through inadvertent disclosure if the client proves that he and his counsel took reasonable steps to preserve the confidentiality of that particular communication. The court found that the client's transmission of the communication to opposing counsel was obviously unintended. His mistake was of a type that is common and easy to make. Indeed, there may be few email users who have not on occasion used the reply all function in a manner they later regretted. You just said something along those lines, Alexis. The court highlighted the fact that counsel noticed the error quickly and immediately alerted his opponent and demanded deletion. The court also explained that in that case, there were facts that supported a potential waiver, primarily that the same error had occurred before and the disclosing party had not filed a motion to recover the email until much later when the opposing party attempted to use the email. But even with those countervailing facts in that matter, on balance, the court still explained that as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosures. It then held that under the circumstances, the email in question was privileged and should be stricken from the record. So in other words, Karen made a mistake. She was in a hurry. She probably didn't even realize that by hitting reply, it was going to go to everybody. She probably just thought it was going to go to her attorney. Fine. She's an active person, an intelligent person. She just wanted to reply to her attorney. She just didn't know or didn't think, whatever. But the other side doesn't deserve to just pounce on that and say, you made a mistake. Now we got your internal communication. I don't think that's right. And again, this is my opinion, but I don't think that's right under the rules of professional responsibility in Massachusetts. Here, Reed sent the email in question at 2:28 p.m. and her counsel notified all recipients of the inadvertent message at 3:07 p.m. And again, this has nothing to do with it really, but then again, maybe it does. This is a week and 2 days before Christmas. Not everybody's minds are, they're on other things. This is the first time. Yeah, this is the first time. I've noticed that things slow down in the litigation culture, at least in Massachusetts, 2 times. Once in the summer and once in December. Nothing gets done in December, but
I feel like that's every industry, unless you're in marketing. Like
Yeah.
everything slows down in December for sure. But yeah, I feel like the most logical step, and again, this is coming from somebody who's not an attorney, but would be, hey, I received something that I shouldn't have. And I have received stuff before that I haven't from clients who are, hey, this is, sensitive to our brand. And, that doesn't, we're not trying to disclose everything to you, the marketer. Fine, fair. Do you mind discarding it? Yeah, absolutely. So I feel like the logical step here would have been, hey, I acknowledge I received this thing. I don't know what to do in this situation. Maybe I'll let the court instruct me on what I should do. I'm not gonna, go ahead and read it. Or if I did accidentally read little bits and pieces of it, fine. But I'm gonna let you know, as her counsel, that I think this matter should be resolved through the court or whatever. That just seems like the most logical step if he wanted to kind of sidestep around things a little bit.
No, I think you're absolutely right about that. If there was any doubt, I mean, I can just hear these attorneys hooting and hollering, look what we got out of Karen. At some point, cooler heads should have prevailed and said, look, this is an issue. And maybe we should, take that email, remove it from the system, sequester it, set it aside so nobody can take a look at it, and we'll go to the court on this. I think you're absolutely right. I think that's where this should have gone, but it did not. So that is Karen's motion. And when I read it, I said to myself, "That's pretty clear. I think that she's right." But then we have to go to the plaintiff's opposition. Now, this is the attorneys for the O'Keefes. They're the plaintiffs in this case again. This is their opposition. I'm not going to read it all. We'll give it equal time, but we're not going to read the whole thing because it's a little bit long. But this is their opposition to defendant Karen Read's motion for an order requiring plaintiff's counsel to destroy inadvertently produced communication. This, the way it's worded, the syntax tells you the type of relationship these attorneys have with each other, at least in my view. Correct me if I'm wrong down below. Plaintiffs respectfully submit this memorandum of law in opposition to defendant Karen Read's motion for order requiring plaintiff's counsel to destroy inadvertently produced communications and strenuously, not just dispute, but strenuously dispute the allegations set forth therein. Defendant Read has presented no valid basis to claim impropriety on the part of plaintiff's counsel with respect to the contested email communication. Ms. Read possesses the burden of proving that the email communication in question is protected by the attorney-client privilege and that such privilege was properly preserved. Plaintiffs contend that any applicable privilege was relinquished when Ms. Read responded to opposing counsel because Read and her team failed to adequately mitigate the clear and avoidable risk of inadvertently disclosing confidential communications. So they're coming down pretty hard. And really saying, no, this wasn't an honest mistake. It's almost like they're saying, no, this was intentional.
How they would possibly prove that, though? How it was? I just feel like there's more hoops that you have to jump through to actually prove that. Does Karen Read have a series of behavior doing this where she accidentally hits reply all? Has she done this before? It doesn't seem like so. So I could very much buy that this was just an accident and a coincidence, and they must feel like whatever is in this email must be, I don't know, maybe some aha, evil scientist mustache twirl moment for them.
Snidely whiplash.
Yeah.
You brought that up, and it's interesting because Karen's attorney, Damon Seligson, later on, 2 documents away, and we're not going to get into every single page and every single line, but he actually filed an affidavit in which he said, no, this never happens. I went through all my communications with Karen, and I can't find any other instance in which I sent her an email or copied her on an email that I was sending out to all of the other attorneys. I've never done that before. So he said that in an email. So that bolsters your point.
Yep.
But then they have a second. This is a 2-tiered opposition, and their second contention is In addition, even if privilege is deemed to apply, plaintiffs are entitled to retain and to utilize the email communication for impeachment purposes should Ms. Reed provide testimony inconsistent with her prior statement. Now, that seems like pretzel logic to me. If she didn't waive her attorney-client privilege, it would seem to me that that email is off the table. Just forget about it. But they're saying, oh, no. Even if the court says that she did not waive her privilege, we can still use the material, which makes little or no sense to me. I want to jump ahead because they go into a lot of background, and I don't think the background will help our fine viewers as much as what they're saying about that ruling that we just read. The Charm versus Cone ruling that had very similar facts. In support of her motion, defendant relies exclusively on the trial court decision in Charm versus Cone, that 2010 Fabricant decision, in which Judge Fabricant held that a client's accidental transmission of a reply all email communication to opposing counsel did not lose its privilege. While plaintiffs concede that now this is the O'Keefe's attorneys are conceding that the general circumstances in Charm are analogous to the present dispute. Defendant Reed and her legal team conveniently disregard the clear. This language is just, it's over the top in my mind. But anyhow, Defendant Reed and her legal team conveniently disregard the clear message from Judge Fabricant warning future litigants of the preventable risk taken by Reed and her counsel here. In finding the question is close, Judge Fabricant cautioned Cone's counsel practice of sending him a BCC, that's a blind copy of emails to opposing counsel with a copy to co-counsel, gave rise to a foreseeable risk that Cone would respond exactly as he did. In sending, the judge is saying this was a close call. This was a really close call, and it could have been foreseen. I'm not sure I agree with that, but I'm not a judge. She is. In sending his response, Cone would have to have known what he was responding to, but nevertheless failed to take careful note of the list of addresses to which he directed his reply. I don't think people do that. I think they just hit the reply button.
They really do. I can't tell you the number of times where I mean to direct a conversation specifically, even over text message as well too. Sometimes you're in a group chat and you forget that you're in a group chat and you start messaging one thing to your partner and you're like, whoop, that wasn't supposed to go in the family group chat, or, over email as well too. So I feel like there's a reason why this rule exists, and that's because, or this case law, exists. It's because it does happen, and it happens so often that they had to create case law.
Yeah. Now, I learned in my personal life, not my business life, but in my personal life, I learned a long time ago, you don't even participate in those group chats. You just don't. Because some time ago, some of the people in my neighborhood, you talk about, do you have a snow plower, or who's having a neighborhood party? So, that's how the neighborhood groups chat got started. It was very innocuous. Then all of a sudden, one person started talking about another neighbor, not realizing that neighbor was in a group chat.
Because especially if you have, like you said before, there's 24 attorneys in this case. Now, I know obviously not all 24 are representing both the O'Keefes and Karenread. They're also the other parties as well. But there are so many attorneys. So, I can't imagine, and especially with the amount of correspondence, I'm sure that is going back and forth on a daily basis. Karenread's not looking at every single email and looking at everything, scrolling up, looking at the email thread, and probably not. So I do feel like and this is my opinion based on the hearing that we just took a look at, the judge is probably not going to take the bait on this one.
I don't think so either. You just mentioned 24 attorneys. Here they are. I downloaded this from a very recent January 2026 list of attorneys that have been notified of an event. And this is the list of all of the attorneys that the court sent notice to very, very recently. And I scratched two of them off because they were duplicates. And so I only counted. But there they are, from Mark Diller and David Buck all the way down to Thomas DeGangi and Matthew Hamill. 24 attorneys in this case, and we only saw 11 or 12 of them in that Zoom meeting. So back to where we were, because a really important point is coming up. On the other hand, a client who seeks to preserve the privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and should avoid practices that exacerbate risks. Here, it appears that both Cohn and his counsel were less vigilant than they might have been. They and others, and notice that the O'Keefe's attorney, adds that emphasis. They and others should take note. Reply all is risky, so is blind copy. Further carelessness may compel the finding of a waiver. Do we still use 2 C's? This has nothing to do with what we're talking about. Back in the old days, when I was first learning this stuff, CC stood for carbon copy. Alexis, do you even know what a carbon copy is?
Yeah, I have heard the term, yes. Yeah, but yeah, BCC, I mean, I really haven't used the blind copy feature, whatever it is, many times in my communications personally. I usually just CC people if I'm adding multiple emails to whatever document.
Oh, I
I'm
do.
trying to send.
Yeah, I use the BCC, but you got to be very careful. And I'm not saying I'm perfect. Absolutely not. And I'm not saying something like this couldn't happen to me. We do all make mistakes, and I've made mistakes.
Sure.
I try as hard as I can. I try to pretend or portend, take whatever word you want, to be a perfectionist. When I send out a document, I try to make sure it's proofread. I try to make sure it goes to the right place. But what I do when I get an email from another attorney and I want to send it to my client, what I do is print. It's real easy with PDF. If I get an email from another attorney, giving me their dissing of my case, telling me usually the weak points, not this. But if I get an email from an attorney and I know that I have a duty and an obligation to communicate with my client, what I do is I just press print. It only takes a couple of seconds. Print, save, email client, attach, send, and then that way there's no chance at all of the attorney or the client, getting to the other attorney, because they do not have the other attorney's email. In any event, so what O'Keefe's attorneys are saying is, here are the precautions taken by Reed and her team to ensure confidentiality of communications were careless, not reasonable. I think they're going overboard with this language. It was a simple have you ever had the experience, and I have, you do make a mistake and somebody really rubs your nose in it, and that's what they're doing here. They're like rubbing the puppy's nose in the pile of what.
Yeah. Oh, yeah. And if the tables were turned, they would be making the same exact arguments that Karen Reed's team is making if they sent them something that they didn't want to send over. So it is very funny in an ironic sense.
So here we get into something where they ventured just a little bit too far, and it was wrong. In all likelihood, by her own direction and or by recommendation of counsel, Ms. Reed has been blind copied on all email communications with opposing counsel since the onset of this lawsuit. Well, her attorney, and I'm not going to read the whole thing, but her attorney, Damon Seligson, one of many and a very good attorney, he said, no. 9, as a general practice, I do not blind copy Ms. Reed on email exchanges with counsel. I have reviewed my emails to Ms. Reed, and I cannot find a single instance other than this one time that I blind copied her on communications with other counsel. Instead, with any communications from and among counsel that are shared with Ms. Reed, it is my practice to forward those exchanges to her by separate email. Okay, he's smarter than me. He's doing it electronically. He's not printing it like me and then sending the printed version. So the fact that I blind copied Ms. Reed on my December 16th email to Mr. Diller was a one-time event. And then he says it was inadvertent. It was inadvertent. So let's get back to the motion that they go out on a limb and they say, by her own direction and by recommendation of counsel, Miss Reed has been blind copied on all, and that's just false. So we're going to run the sound effect and move on to the next section. So that was one. That was their first argument, was that it wasn't inadvertent. It was careless and reckless. It was not a mistake. It was reckless. And so she herself, waived any attorney-client privilege. So their next argument, even if Ms. Reed did not waive privilege, plaintiffs are entitled to use the subject email for impeachment purposes. And I just think this is wrong. But they cite a case in VigorWorks versus Shanska, which is a 29 case. Again, that's almost like yesterday in the law. The court held that while a party's inadvertent disclosure of a privileged communication did not amount to a waiver under the circumstances, such finding did not preclude use of the communication by opposing counsel in the future to assess credibility. Now, I'm not going to go into the whole thing, but that is a particular case. It's another Superior Court case, which is not mandatory authority. And Attorney Seligson, again, on Karen's behalf, said, you know what? Nuh-uh. First of all, it was inadvertent. It should be, the attorney-client privilege should be considered to stand and not be waived. And they also said, not only is plaintiff's alternative argument that they should somehow be allowed to keep defendants inadvertently produced non-waived attorney-client privilege communication for impeachment purpose is equally basis. On February 2nd of 2026, Reed served her answer to a second interrogatory, and even a cursory comparison of the two documents, the answer and the privileged communication demonstrates that the privileged communication does not provide plaintiffs any additional areas for impeachment. So to me, that was a little confusing, because if it doesn't provide, an aha moment or a dun moment,
Right.
why are we fighting over this? So I don't know. My guess, I don't know. I'm not a judge. I'm not in that pay scale. But my guess is that a judge is going to say, nah, it's waived. It's not waived. Karen Reed made a mistake. Let's not pounce on it. Guys, when the shoe is on the other foot, I think you said this just a few minutes ago, you yourselves are going to be saying, you know what, we made a mistake. So we attorneys are supposed to be amicable. We're supposed to be professional, even if our clients are at each other's throats, which happens. Hopefully not literally, but I've had clients that just literally hated the guy on the other side and just had nothing nice to say. We're all members of the bar. In Massachusetts, some people don't like this, but we call each other brother and sister. So even the insurance defense guy who's saying that my client is a fraud and a faker and wasn't injured and all, we're supposed to be, and we have, I've attended horrible motion hearings where they just lambasted my case. And I, said, well, the insurance company this, the insurance company that. In the motion hearing, you can't talk about insurance in a trial. But then afterwards, we go out for a cup of coffee and talk. That's happened to me. I've actually befriended attorneys on the other side. I told the story. And again, my viewers hate when we tell stories, but I had a case that went on for a horrible property dispute that went on for a couple of years. And our clients were literal at each other's throats. But the other attorney and I realized, less than halfway through, let them duke it out. Let's go out for coffee. Let's, and in the end, knowing that the judge didn't like any silly business, we actually sat down in a conference room and agreed on 90% of the exhibits. It's like, why PO the judge by fighting over exhibits when you can agree on 90% of them? So, we ended up being acquaintances, not best friends, but that's what we're supposed to do. And I don't know, to me, you tell me, because you're an intelligent outsider, it just seems that these parties are at each other's throats with the language that they're using.
Oh, yeah. It definitely seems somewhat ego driven. And, of course, you're going to see that from time to time. But a lot of the impeachment argument almost reminds me of Hank Brennan utilizing the clips from Karen Reed's interviews that she had done in the criminal trial, the second criminal trial, and trying to take certain things that she might have said in this maybe slightly out of context and then using it to potentially impeach her statement or another witness's statement later on in the trial. And it almost reminds me a little bit of that, is like we're trying to anticipate something that might not even happen. She might not say something that may contradict this thing this mysterious thing that she said in the email. So you might not even be able to use it. It might not be anything big. It might be a nothing burger. And again, we can speculate until we're blue in the face about what that email exactly said. But I don't see, especially with how this judge has appeared to be displeased about the pacing of how all this is going. I don't think he's going to want to waste time having the O'Keefe's attorneys go through all however many. I'm pretty sure it's probably of the thousands of email communications between.
So easily.
Yeah, and having to produce that. I mean, if she really was BCC'd on all of these communications, then produce it. But
Yeah.
who wants to do that? Who wants to sit
No,
and
the
wait
judge.
around
The
for
judge
that?
is already not happy that the discovery phase is not going as quickly as he'd like. He wants to have motions to compel people. The Mass State Police have not produced one document, according to the attorneys in the Hollywood Square hearing that we just had. The Proctor's phone he lost his phone. Give me a break, Mr. Proctor. Come to my office Monday morning, and I'll sell you a deed to the Verrazano Narrows Bridge for $10. I mean, give me a break. But anyhow, I think the judge has his plate full, and he really doesn't want to get into all this. I might be wrong, and we'll see, and we'll cover it. And if I'm wrong, I'll say, hey, look, But that's the way it's going. Going back to something that you said before, I think in retrospect, very few, if any, of those statements that Hank Brannon used, the statements that Karen had made in various interviews, whether it was 2020 or to any other, I don't think the jury found any of that convincing, with the one exception of, she did admit that, she was drinking and she was driving. And I think that statement, she convicted herself of OUI, drunk driving. But other than that, I don't think the way that he used those statements was really out of context. He would be interviewing one witness, and then he would say, what was the woman's name that did the evidence, whatever it is? Would you please play clip number 427? Yeah. And it's like, what? Where? How? It would be like me playing a cartoon right now, because it's just out of context to what we're talking about. And I don't think any of it really convinced the jury of anything other than that one thing that I said before. So I don't know. I think we're lucky to get this thing to trial by sometime in 2027, because we're already, I can't believe how fast time is going. We're already, getting into February, March, spring is coming, the slowdown period in the summer. But I think that the judge has kind of, sent a shot over the bow that, I want you guys to hurry up. I think he's a little bit upset that, this case was filed way back when, and the Reed people came in and said, wait, we want to stay with respect to Karen so that, you can't force her to testify when the criminal trial is ongoing, claiming the Fifth Amendment right. So the court allowed that, but now the criminal trial has been over since June 18th of 2025. And the judge is like, really? You haven't done anything since then? So I don't know.
Yeah. I mean, you had all this time. Exactly. That's exactly right. Yeah. They filed that, like a year and a half ago, maybe?
Yeah, something like that.
Something ridiculous. Yeah. It's like you had all this time. So what gives? So I am curious, though, to see how, I imagine when Proctor gets deposed, it'll all be behind closed doors and all of that. But I am curious to see if that starts to get the ball rolling a little bit more.
Well, that's what the attorneys are saying. We can't do depositions until we get the documents. And that's true. When you do a deposition, you want documents that you can ask people about. Yes. So if the documents are not forthcoming, you really can't do the depositions. And they're even having trouble at the level of opening up files. So, I don't know. I didn't do any viewer comments this week because I knew that this episode would go long. I appreciate you being here so long. Usually our episode, you do quick ones, and I like that. I get up in the morning. I'm drinking my coffee. And, oh, Alexis Room just did another one. And it's informative. You really have a good grasp on the facts, but you make me laugh every time. So yours are short and pithy. Ours generally go 45, 50 minutes, and that's it. So this is kind of long for us.
Yeah, I usually try to. It's funny because the videos are short when they're edited down, but it actually does take me like an hour to an hour and a half to actually record it, and then another like 2 hours or so to edit it down and get the most important bits too, and go through a couple of different rounds of editing. But I find that's the best way that my brain processes information. But I love watching your content because I
Thank you.
get the legal perspective of everything, especially from somebody who is there and has worked with some of these, not necessarily some of the attorneys listed on the case, but some of the judges, etc. So I always find it helpful for me in creating my content and having that legal understanding.
Well, thank you. There are attorneys all over the country that are covering the karenread and all the other associated cases. You had mentioned the King case. And there's a lot of others. I think, and I welcome that. I mean, these cases deserve recognition. These cases deserve to be looked at. So don't take this the wrong way, but I think I'm about the only Massachusetts attorney that covers these cases at any extent. And I agree. It takes a long time, not only preparing these cases. You got to do your research because your viewers are going to tell you if you're wrong. Even if you're not wrong, they're going to tell you you're wrong. I get that all the time. But then editing, you got to edit it. Somebody said to me, well, I don't know why you don't do it. Just do it live. So many things can and do go wrong in lives. I hate doing lives. Do you do lives at all?
No, I don't. I don't. I've been invited to do some live streams, fundraisers, and those are always fun.
Yeah.
And I find that I usually bounce better off of other people instead of being the host of a show, because then you also have that as well too.
Right.
But yeah, I agree. I'm somebody who needs to have my information laid out and room to make mistakes, as we talked about at extent on this video. People make mistakes, and sometimes my brain moves faster than my mouth does, so it's nice to say, hey, I could just do that thing over again and get a clean take of it.
Yeah, Laney and I did a series of lives back in the fall. I think we did 5 or 6 of them, and I'm just very uncomfortable. I'm very uncomfortable doing them, and I found myself either deleting them and going back and editing them, or just editing them and reissuing. And there are some people that are really good at it. And I want to mention Lucky. He does a great live. He's really good at it. He does a really good live. He just has that ability to just, think on his feet and organize his thoughts. And there are others. I don't want to leave anybody out, but I mean,
Totally.
Do you have any closing thoughts?
I mean, my biggest closing thought is Proctor's going to make things as difficult for everybody as possible. And the plaintiffs might see that maybe right now as a slight advantage for them. But I think in the long run, he's going to end up messing and muddling a lot of different things for everybody. So I think it'll be quite some time before we see this case get any sort of legs. But in the meantime, I think there's a lot more to come in terms of evidence. I'm really curious to see what those 518 video files entail, and then what, again, actually ends up coming through. So
my closing thought is about the same. I think it's going to take a long time, and I wish we could see discovery. But as you pointed out, even though Proctor's deposition is scheduled in April, the first question is, will it really go? Because many times depositions are continued. And 2, generally they're private. They are private, even though there's very likely going to be video camera in there, maybe not. It is very likely that we will not hear about it, and that's sad. But I believe they've said that it's very likely going to be streamed. Oh, the last thing is Yoli's not here because she had depositions today. She had a scheduling issue. But the last thing we always do is ask our viewers, if you've been with us for this entire episode, please leave us an emoji. Do you have any ideas for an emoji?
Oh, I feel like some kind of shaking the head emoji, or some kind of frustrated, some kind of headache.
A headache. Is there a headache emoji?
Palm. There might be. I think it's like a Band-Aid. It's more of a sick emoji. There is a face palm. I feel like that might be appropriate. as
Oh,
well,
I never saw that one, but if people want to leave that, that's fine. If they alternatively want to leave an aspirin, that's good.
Yeah.
All right, Alexis, thank you so much. Thank you so much. It was really good chatting with you. Be well and keep on putting out your great content. It's fantastic.
You pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.